Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome back to another episode of Just Verdicts. I'm your host, Brendan Lupetin, and today I'm once again talking with Clancy Boylan. And Clancy, you are the first three-time interviewee on the not so long history of the Just Verdicts podcast. But congratulations, because that means you've yet again hit another noteworthy verdict that a lot of people want to hear about. So congrats and welcome back to the show, dude.
Yeah, thanks for having me. I'm hoping do a couple more of these and you can get me a 5-timers jacket.
Yeah. It's lofty goals, but I'm confident you'll be the one to achieve it. So, we've done this before, so we don't need to hear about any of your background anymore. We just want to get, right to the meat of the magic of how you're pulling these verdicts off. And we're talking today about the verdict. Is it Wilson v. Beiler? Is that how you pronounce that name? Okay. So tell us a little bit about the facts of this case, and I'll be really curious to, based on reading about the case, what were, from your vantage point, the reasons that the defense or the insurance company or whomever took such a hard line in letting this case go to trial. So just start with like a summary of everything.
Sure. So July 16th, 2022, Heath Wilson was riding his mountain bike on the trail in Lancaster on the low-grade Enola Trail. And one part of that trail intersects with Bushong Road. And as he was crossing over Bushong Road, Donald Beiler, the defendant, was driving a JM Lapp truck, kind of like a work van, and the ledger's going too fast, not paying attention. He hits Heath Wilson in the designated crosswalk. Heath goes up on the hood, hits the windshield, and then gets thrown 25 feet. Suffers horrific grade 3 diffuse axonal brain injury, in a coma for a couple weeks, in the hospital for several months, brain rehab, discharged to home, doesn't work, goes back to the hospital, and then was in there for a couple months, went to Johns Hopkins, and then has been in a long-term care facility ever since. 51 years old. He was an incredible man before this. He was so active hiking. He was biking 300 miles a week. A couple months prior to this crash, he did a competition in Michigan. It took him 18 hours to finish it. This guy didn't waste a moment of his life. And unfortunately, this took his life pretty much.
So the images, because in your pretrial statement and trial memo, there are still images, which I'm assuming must be, were they recreations, those images?
From the vantage point of the defendant Beiler?
Yes.
Yeah, so what we did is, unfortunately, Heath Wilson had no memory from the crash. His last memory was a vacation he took with his girlfriend Susan several weeks before. And we also didn't get a call until, a couple months later. Susan actually reached out to me. So we didn't have that, crash happens, we can get to the scene. So we had photos from the police of some of the tire marks, the gouge marks. We had photos from the defendant, as Heath Wilson is laying on the ground, completely unconscious. You could hear gurgling sounds from inside of him, from the bleeding inside. The defendant standing there taking pictures. And you could see our guy laying on the ground, which jury wasn't thrilled with. But we hired DJS. If nobody's used them before, they are a wonderful, wonderful company. Justin Shore and his team, they just do great work. And what they were able to do, and this became an issue because one of the theories of the defense from their accident reconstruction they hired was that the defendant, the reason why Heath Wilson was at fault is because the defendant couldn't see him because his rear view mirror and his easy pass was in the way, blocking vision. But Justin was able, because we 3D scanned everything after we were finally got involved, and he was able to show from 100 feet, which we all agreed was pretty much the sight distance between when he could first see the trail, and you could see where Heath Wilson was on just about to enter into the road. Easy pass, rear view mirror played absolutely no role, and they actually abandoned that theory after openings.
So the defense was, at least at some point, trying to suggest that the rear view mirror and the easy pass were what obstructed his vision, and that's what contributed to it, and somehow that was going to help lessen the liability?
Yeah, what they're saying is that Heath could have seen the defendant longer than the defendant could have seen Heath because this, the mirror was in the way. And this just, when I had Justin Shore up on the stand and we went through this, it just completely blew that out of the water, and they didn't even, by the time they got their accident recon on the stand, they didn't even mention it.
Did Dr. Shore help create those images from the vantage point of the driver?
Yep. Yeah. So What we knew is because we had tire marks, so we knew the speed of Donald Beiler. He was going 34 to 38 miles an hour and then hits the brakes, jams on the brakes, and he's able to get it down to 29 miles an hour when he hits Heath Wilson. So we knew speeds. We also, Heath Wilson had a Garmin watch, and that had an average speed of 5.4 miles per hour. So using that, and then with the 3D scan of the whole area, 3D scan of the vehicle, we were able to pinpoint where everyone was. And the interesting thing was, we did a full, complete accident reconstruction. The defendants chose not to do that. They kind of just played Monday morning quarterback with Justin, agreed with the numbers, but then tried to argue. And one of my favorite moments of trial is that they asked Dr. Shore, you would agree with me, physics changes? He said, what? He goes, you agree with me, physics changes? He goes, no, physics is perfect. I used that in my closing too. I said they're going to try and tell you physics changes, but ladies and gentlemen, physics hasn't changed since that apple fell and turned Isaac Newton's head.
Yeah, I'm trying to figure out where they were going with physics changes thought process. So, is the entire case, as far as establishing liability and what happened, since your client, Mr. Wilson, is completely amnesic to the event, is it entirely from the reconstruction that Dr. Shore put together, basically?
Yeah, and then that's always, so we had the reconstruction, we had, the testimony they got from the defendants and the corporate rep. One other key piece of evidence is that on this road, for the driver, for Donald Beiler, there is a penned out warning sign, the diamond-shaped yellow sign with a pedestrian and bicycle crossing. And it's a warning sign telling you to slow down. And this was a very, very busy trail. And this is a Saturday afternoon, 78-degree day, beautiful sunny. Whereas Heath Wilson does not have anything. And in fact, 3 days after this crash, they put a stop sign up there for the trail.
So let's talk about a little bit some of the before lead up. Okay. I can see, maybe some of the arguments from liability, and I think that 15% fault was apportioned to Mr. Miller. And what do you attribute that to? Just maybe they felt he should have been a little bit more aware of going into the crosswalk because it nevertheless is a road type of thing?
Yeah, I think it was one of those where they said hey, he could have stopped, seen Donald Beiler, 100 feet or more away and determined that he was going too fast and maybe I shouldn't go out. And so I thought that the 15% was fair, and the how I kind of probably would have looked at it too. I never argued that we were at fault. I just knew that we were going to probably get tagged with something, and I was hoping it was going to be 5 to 15%. So that kind of
that fit within what you were thinking. So on that, we hear a lot of attorneys talk about that in certain circumstances, say, your client was clearly someone at fault. Some people will sort of take head on some amount of comparative fault, some percentage. Other people don't, but still kind of expecting that they might get hit. Where did you come down on this case insofar as, did you ever consider saying, hey, if you put a little bit on, Mr. Wilson, we would understand that, but it's pales in comparison to the fault. Or as you said, you didn't really address that at all or concede at all that he was at fault, but nevertheless thought that he might get hit with a little bit of it. Like, what was your thought process on balancing those two?
Yeah, there's one thing that I actually thought about maybe doing was saying, like, look, as I'm walking up through the verdict slip, as like how I like to do that is, if you do find that he was negligent, I thought about making the argument that his negligence wasn't a causal factor because his injuries were caused by the extreme speed of the defendant.
Yeah.
And I ended up just abandoning that and just because it all depends on how trial goes, what comes in, what doesn't come in. And I felt like at 4:30 in the morning, as I'm like figuring out what I'm going to say that morning for closing, they just didn't put enough evidence. In fact, I thought they didn't put any evidence in the bucket for negligence on Heath Wilson. They basically gave a bunch of theories and then just never supported it. So based on how the week went, I knew the right move was don't concede anything. And then the two people I tried the case with, Hannah Moltorus and Grant Gillenwater, who were fabulous, we all came to that consensus, and that's a preference thing. Some people will do it, but I just didn't think it was necessary.
In the, I think it was the Legal Intelligencer article that was published a day or so ago about your verdict, they, I believe, referenced that the top offer from the insurance company was $500,000. Is that true?
So I had made, 3 or 4 policy limits demands, withdrew them, gave them another shot, and finally, like, I don't know, 3 weeks before trial, 4 weeks before trial, the defense produced their economic reports, and their own economics were between, on the conservative end, like $4 million, and on the high end, about $8 million.
Is that for medical?
For medical and wages, yeah.
Okay, gotcha.
So they're putting $4 to $8 million on the board. And again, and their argument was, my guy's going to die in 10 years. And they also subtracted from his wages for this, like, absenteeism or something like that when there's no, and we can get into that later. But, so my final letter to them was like, look, you're putting $4 to $8 million on the board. And that doesn't account for, a guy who was one of the most active guys I've ever read about, known, or anything like that. And everything was taken away from him. So the non-economics in this case are huge. Even if we get 50-50, I'm over your policy. And so I gave them until like the Friday, because that following Tuesday, Dr. Mbeo, my quadruple board certified brain injury doc, he was set to testify. And I said, like, this is it. Trial starts. And they called me. I gave them until 3 p.m. that Friday. They called me or emailed me. They needed till 4. And then they offered $500,000 and then said, or we'll agree to binding arbitration, low at $250, capped at the policy. And it was like,
what? Yeah. What? I mean, do you know why do you think that? I mean, and again, I will just point out, and this is, this is no slight on you because you capitalized on it, but, a lot of younger attorneys, they're kind of wondering, like, how do you, get a great verdict? And a lot of the times it's because the defense makes terrible decisions that allows you the opportunity to try a great case. And really, I mean, this seems, what was their rationale? Why were they, what did they think was going to go in their favor here?
I got a couple theories. One, I think they put a lot of stock that this case was in Chester County.
Which I heard is, I don't know the East as well, but I did hear from a friend of mine, Andy Raymeyer, give him a little shout out, that Chester County is pretty conservative.
Yeah.
or even maybe somewhat rural to I'm not,
Yeah,
yeah,
it's a little
okay.
bit of
It's
both.
not Philly or like, a Bucks or something like that.
Exactly. So
So they're
it's
counting on the county.
counting on the county. I think they always thought, like, again, we approach every case, and I approach every case like it's going to go to trial. So I had this thing set up from day one that it's going to go to trial, and I think a lot of times they have it set up that they're just thinking, okay, with some liability issues, and you've got this person who's catastrophically injured and who needs money, it's going to be a lot for them to go through this trial. I mean, he's not even going to be able to be there at trial. I think they just thought we were going to negotiate and come to a resolution, for several $1 million. And that didn't happen because, I believed in my client. I believed in his girlfriend, who was just absolutely fabulous. I believed in our skills in the courtroom, that we were going to try a good, clean case, quick case. And I believed in the jury that, that Hannah picked, that they would do the right thing. But I think that's what it was like. It was a little bit of a liability issue, and it was Chester County. Like, they really thought there was no way a Chester County jury was going to do what they did.
So just banking on the people, pretty much,
Yeah,
at
and
the end of the
banking on
day.
us folding, which I mean,
Well, I'm surprised by that, given, I mean, you've been in a really good role lately. It seems like maybe they didn't do their homework, and they weren't listening to my podcast, clearly, to hear about your all your prior verdicts and the hot streak you've been on. So yeah, it just seems crazy to me that they would have approached that. Did they try, to the extent that you can share this, like during the course of trial, did they, nevertheless try to come up with more money to entice you at all, or did it nothing, just never changed?
never said a single word to me. I mean,
Yeah.
we put on honestly, like a flawless case.
Yeah.
Never approached me. Gave a 47-minute closing that I feel like was the best closing of my life, and get into why I think that later. But nothing.
Yeah.
Nothing.
That's wild.
Not even like I asked for a high low, like zero.
Well, I mean, isn't that at the end of the day, I mean, it's good that was fortunate for you and your client,
But
I
back to
think,
your
in
point,
hindsight,
they gave us the opportunity.
Yeah.
We took advantage of it.
I want to talk briefly about some of the motions in limine on both sides. So defense, I guess, was trying to bifurcate.
Try to bifurcate. We obviously opposed that. The law in Pennsylvania is against bifurcation, and we had a really solid brief on that. And there was no reason to bifurcate it. I originally, and I about this, as funny as I had punitive damages in my initial complaint, because I filed it in Philly. Learned very quickly, like, they did zero business in Philly. I'm like, okay, let's transfer it out of Philly, and then it was really a choice between, and in their response, they told me they did business in Chester County and Lancaster. And I was like, well, I want to be in Chester County more than I want to be in Lancaster. Plus, I know Chester County moves a lot faster, and I'll get to a jury quicker. So we settled on that. But we had a very good brief on that, and the judge in her order said, it's the preference is not to bifurcate things, and it also would have made the case go longer than a week if we bifurcated it.
Yeah, and obviously the sole reason the defendants want to bifurcate is because they know that factoring in the catastrophic damages, is from their perspective going to impact the liability as well. They want to make it just this like clinical, fact only in a vacuum type decision.
Yeah, and the wild part though is, like, I'm still going to put my guy on to testify, and we'll get into that, like how that whole thing. So it was like, they're going to know my guy's hurt.
Yeah. Was there any pushback? Because I assume you did not have, I think you even said this, you didn't have him in the courtroom for most of the trial, right? Given his injuries.
Yeah. Heath is, unfortunately, the insurance company no longer is providing Heath with therapy. And so when he was getting really skilled therapy, which kind of was part of our theme, like when he was at Hopkins or he was at Penn State Hershey Medical Center, like when he was getting therapy, he was making progress. He was taking steps. He had a nurse standing with him. He had a walker. And then as he gets to this long-term care facility and they take away his therapy, he's now bedridden. they need a Hoyer lift to get him out of there. And then he can get into a wheelchair, but he really can't sit too long because he had a couple thoracic fractures and he had really bad toxic pain that he was getting like ganglion RFAs. And so he couldn't sit for a long time. Plus he was an hour and 20 minutes away from the Chester County Courthouse. So we had requested that he be there, but he was going to have to be there in a hospital bed. And Judge Black, who was phenomenal.
in the courtroom.
Yeah, she's like, yeah, we cannot fit a hospital bed in the courtroom. So
yeah,
the next best thing is I sent my associate down with the laptop, and he testified live via Zoom.
Oh, so he actually never physically came to the courthouse.
Correct. His girlfriend was there the whole time, except for when he testified. She stayed with him for support, and then immediately got in the car and drove for the afternoon session.
Did the defense try to subpoena his presence there at any point, whether it was for jury selection, any of that? Sometimes they'll do that in order to help identify sympathetic jurors. They didn't do anything like that?
No, I mean, when we argued to have him there kind of at the pretrial, they're like, look, we defer to the court. I mean, obviously we don't think he should be here in a hospital bed, but like we defer to the court.
Yeah.
And so I'm glad we did it the way we did. Like, and I knew, because I was, if he was going to be there, I was only going to bring them there for his testimony. That was it. I didn't want him there, any other time, so that people think we're using sympathy or even on like the alternate is like kind of get used to it.
Yeah, well, right. I mean, that's what you worry about,
yeah.
is they get desensitized to the extent of it. What did you cover with him since he was amnesic? I imagine it probably wasn't too long of an exam of him, right?
No, so he was our last witness.
Okay.
So we opened on Monday, went Tuesday, and then Wednesday morning we did Dr. Romy Toda. We played Andy Brazili's video, and then Heath was our last witness. So we took a break because we had to make sure that the Zoom connection was all good. So judge walks out, jury's out. We put it on, and then you could see Heath. And up until that point, we had only showed photos of Heath before the crash.
Yeah, that's
and you
great.
could see he was like a good-looking dude. He was jacked, very physical fit. And so we get it set up, and you see Heath on the screen for what how he was after the crash. Judge walks in, she looks at the screen, and kind of head goes down. The jury walks in, they look at the screen, and their head goes down, and you could see some of them already start to tear up.
Yeah.
So, what I wanted to establish with Heath was, before the crash, like the things that, he had a zest for life, and asked him, did you ever waste a moment of life? He's obviously, no. And then we talked about the care. Like, Heath, would you give anything in the world to have the means and, access to the care that you need to get better? And obviously, yeah. I can tell you, like, when I did like a mini prep session with them the night before, I was bawling my eyes out.
Yeah.
And I wrote a verdict recap to the firm, and like 2-3 years ago, I don't think I wasn't in a place where I could have gotten emotional, and both in that direct and in my closing, but did a lot of work on myself and a lot of mental health stuff, and I was able to be in the moment. And my last 2 questions to Heath were, Heath, everything that's happened to you, have you ever thought about giving up? And his answer was, yeah. I said, but are you ever going to give up? And he said, no. And there was this long pause. And he said, I have too much to live for. Now here's a guy, 51 years old, in diapers, sitting in a long-term care facility in a bed that he can't get out of. And I mean, I lost it. And I think defense counsel maybe thought I was, theatrics. I was like, do you need a moment? I look over the jury, they're all bawling their eyes out. And I think right there, they knew, this guy, that was the start. They're going to fight for this guy.
Yeah. I mean, that feels super powerful. I mean, you can only imagine what it was like being in that courtroom at the time. I mean, you just sort of matter of factly, mentioned, I think, several, I think, really critical points that a lot of people don't consider. Number one being, I think it was such a good, such a great idea that, the case is all about, and the image of him is before and what he was and, how great of a life he had. And I think a lot of people still to this day, they think they should jam the injury and the current state into the juror's face. And, but without that contrast, and I mean, clearly just the face of the judge, the face of the jury, when they've been seeing one guy, this specimen mountain of a man, so physically fit and, has that zest for life. And now you're seeing him, and it's almost, because even just in the trial brief you sent, the contrast between the photo of him and his girlfriend beforehand, and he's, looks like, freaking CrossFit guy, and then afterwards, and he just looks so, just kind of unfortunately withered. He's just been through hell. It's so obvious, like what was taken from him. And I think also just your ability to allow for that pause too in that moment. I think a lot of people get antsy and they want to just kind of insert something, and you just kind of like let it sit, and then, he has that opportunity to, to kind of provide the full explanation, which I think just kind of capped it all off. So it's amazing stuff.
Bookend to our case in chief, because we started our case in chief by putting his girlfriend Susan on, who was just, I mean, they had only really been dating for like a year or two before this crash happened. And, Hannah and Grant and I, as we, would sit every night, like recapping, we always asking ourselves, like, do you think in that position you would stay?
Yeah.
And she, not only did she stay, I've never seen somebody fight so hard to get him the care that he needed. And she ultimately, she couldn't towards like in the last like 8 months, because it's just, and she's called place after place after place. And she talked about that. And she, and that again, fit into our theme. And she, all the places I called trying to get him in, but nobody could take him. Nobody would do it. And her love for him was just unbelievable. And so it was a good bookend. And what made it even better is, so I finished that question with him. Jury's crying. They crossed him.
I was going to ask you. I was like, they're not going to cross him, right?
Cross-examined him, ask him questions like, "Hey Heath, you like to ride bikes, right?" God love him. And like his voice was so impacted because he was, yes. He said, "You like to ride bikes real fast, right?"
Oh my God.
Yeah.
The gifts you get sometimes. You can't plan for that.
We got 3 or 4 gifts in this case that really helped.
Yeah, I mean, you've already mentioned, the driver standing over him, taking pictures for the incident report for a guy that's, probably dying at the scene almost. You've got cross-examination of, an uncrossable plaintiff who's just given the most poignant testimony. What were some of the other key moments, do you think?
The other key moments, like in our case in chief, obviously, I mean, Susan knocks it out of the park. That one, I tried hard, and like I'm welling up. Jury was crying with her. Dr. Shore did awesome. We called the defendant, and he had always testified he was going 25 miles an hour, and Grant Gillenwater, my law partner, was crossing him and said, like, "You understand that not even your own expert says you were going 25." And he said, "I was going 25," and we got him to admit, and you were going 25 because you knew that was the reasonably safe speed for that road with everything that was going on. And, he agreed to that. That was great. I had, in the discovery depth of their corporate rep, I'd asked them, we can agree, you don't have any evidence that Heath Wilson wasn't allowed to enter that road. And their answer was no, we have no evidence of that. So we were going to read that part in, and they objected and said, read the whole thing in. Rule of completeness, which isn't really the actual rule. If there's parts below it or, before it or after it. And Grant, who's going to read it in, goes, fine, screw it. Up on the stand. And the judge,
oh, yeah.
Yeah. So the judge was like, well, that's not how we do this. He goes, sorry, Your Honor. We would call the corporate rep to the stand and put him up there. And he wasn't ready for it. And we read him that line, and you still agree to that to this day. And it did not, it was just not a good look for that. They should have just let us read it in. And so that was another gift they gave us, but probably one of the biggest gifts they gave us. Their expert talked about a Pennsylvania Motor Vehicle Code. It was 3324 entering at a non-intersection. And Heath was cited but not charged. Their expert, and now they filed a motion to eliminate to keep out the police report. And we're like, fuck yes. We wholeheartedly agree with this motion to eliminate. And their expert on the stand Bill Camlin, he was in the military doing recons, and then he was a state trooper doing recons. And the jury was buying up because he's got a very impressive background. And he's talking about the Pennsylvania Motor Vehicle Code as a state trooper. And he says that, and the Pennsylvania State Police charged Heath Wilson with violating, and I shot up, objection, sidebar, and I'm fuming. This is the last witness in the case.
Yeah.
And it was a bell that cannot be unrung. And,
sure.
And I thought about do we reserve it? And then Grant and I are looking at each other, and he's like, it's such a core issue. I don't know how we come back from that. And Judge Black, who had just said it before, I got to say it again, she was an absolute pleasure to try this case in front of. She did a very cool thing. She, I'm sure, noticed that we were very hot. Hannah and I wanted to murder somebody. We came all this way. Our client's girlfriend is just breaking down, uncontrollable, that she's been through this. Heath had to go through it. What does this mean? She said, take a break. Sends the jury out. She said, I'm going back to my chambers. I'll call you when I'm ready. She brings us back and says, this is what I'm going to do. As soon as we get out there, I'm going to call the jury back in, and I'm going to say, you are to disregard the testimony that you just heard from Mr. Camlin. Heath Wilson was never charged or cited with any Pennsylvania Motor Vehicle Code violation. Grant and I look at each other and we're like, that's pretty good. Good.
Yeah.
Expecting them to say no,
objection.
Not
accurate, whatever.
Yeah, that's fine with us. So the night before, I'm trying to write a cross-examination to show that this was an actual intersection that he's coming from.
Yeah.
And it involved using definitions from the Pennsylvania Motor Vehicle Code. If I do that cross-examination 10 times, maybe I hit twice. Maybe. It was just not fun cross-examination.
Mm-hmm.
And so now I don't have to do that.
Yeah.
And so they come back, she gives that instruction, and the jury now kind of looked wow, he just said something that wasn't true. And they continued to talk a little bit about the Pennsylvania Motor Vehicle Code. So my first question when I stand up was, sir, you kept talking about the Pennsylvania Motor Vehicle Code after break. You heard the judge, right? You heard her instruct the jury to disregard your testimony, that it was not accurate. And that Heath Wilson was never charged or cited with any motor vehicle code violations. You heard that, right? Yeah, I heard that. It's okay, boom, that's done. It was a gift from the gods.
Yeah.
And that made that was a big moment.
Yeah, I would imagine so. Interesting. I want to talk about just quickly some of the other MILs. I want to hear opening and closing thoughts, and also just kind of a little bit more on the order of proof. So I noticed that one of your MILs was no references to your firm. And is that because you've encountered defense lawyers kind of trying to play up the fact that you're part of, big Morgan and Morgan group kind of thing? Or I mean, you've run into that before?
Yeah, the last bunch of trials, we've got that we're manufacturing cases, that we're doing this, we're doing that. And, I've handled it in the past, but I was just like, what, screw it. Let's just file a motion. And the judge has been pretty good about it. We actually, in another trial that we had, someone else said we filed it, and the judge was like, "You're not going to do that, right?" And I'm like, "Yeah, no, we're not going to do that." Like,
right. Yeah. Then that's all you need.
Yeah.
You know what I mean? Yeah. So that makes a lot of sense. What was, to the extent you can share, what was the collateral source MIL? So just where his benefits had come from? Okay.
Yeah.
And then I saw that you also did an MIL that you didn't want them, and I encounter this in the medical malpractice arena a lot of, oh, we're a community hospital, a small country hospital, and same thing you were anticipating, the Beiler's company would say, oh, we're just a small mom and pop shop, to gain the sympathy of like, don't punish us, we can't afford it kind of thing. How did the judge receive that?
Pretty well. That was one of my biggest fears in this case, was that for them to deliver justice in this case was going to require a big number. And this is a small mom and pop plumbing company. Like, it's not like I'm going up against Penske or some other like large corporation. Like, this was a mom and pop plumbing business. And, while most people know insurance is involved, there are people that still don't know that.
Yeah.
And so that was a big fear. And one of the things, like, they referenced a lot about their like faith in God. So what I did not want was them
Who, the company?
Yeah.
Oh, wow.
So
okay.
it was like a 2-part motion eliminate. No references to that, and then like not to talk about it. And I knew they were going to be able to get somewhat in. She's like, I don't want to talk about, like, you could say like it was founded in this, we have this many employees. It actually turned out they now have 52 employees, which sounded a lot better when it came out.
Yeah.
But she was very good about that. She's like, yeah, I do not want you. And we said, it's just like us trying to like gain sympathy. That's them getting sympathy.
Did you argue that? Did you point that out in closing? Because I'll do that in closing or in opening too. This isn't about sympathy. I've got a job to do. I've got to show you the damages and the harms and what's been taken from my client. I'm not doing it to get your sympathy. I literally have a job. You've got a job. If you don't have that evidence, you can't make a fair and proper decision. But that's a two-way street as well. No sympathy for us and no sympathy for the defendant too.
Yeah. So I didn't argue that. Now, in opening, Grant did say that. He was like, look, I want one thing, your decision at the end of this case cannot be based on sympathy. It is not allowed under the law, and we're not asking you to do that. So we did point that out, like, right from the start, like, because we knew when they see this guy, they're going to have sympathy. But we pointed that out. And in the end, I didn't really touch on that. There's some other, like, I went about it in a different way.
Yeah, I think if you hit it in an opening, that's all you need to do. So Grant did the opening?
Correct.
Can you give me kind of general structure on how he approached it in this case? I mean, was it rule-based or, what did you guys do as far as format?
Our theme in this case, as it is in most cases, it's all about taking responsibility. And one of the things we really hit on in opening was, it's about evidence and facts. It's not what I say, what you say, like what the lawyers say. It's what you hear in this courtroom from the witness stand, from the documents that you see. It's all about quantity and quality, because we felt like we had that, and they were going to come in, give you theories, and just not really back it up. So that was a heavy, emphasis on it. And then it was just also contrasting the experts that you're going to hear in this case, because, we had Dr. Mbeo. He was board certified in neurology, neurocritical care, brain injury medicine, and interventional pain management. He takes care of approximately 300 severe traumatic brain injury patients every year. Their life care planner, who they were really using to just give, not like where we bring in Varsha and she's just using Dr. Mbeo to put numbers on it. She was actually Dr. Cantor trying to give opinions. and she's a pediatric doctor, never treated a single brain injury patient. So we want to, that compare and contrast. They also had a neuropsych, Dr. Spector, who we were going to play in our case in chief if they did. And then, so that was a big issue. It was like, look, we're bringing you the people who actually specialize in this stuff. They're bringing you pediatric doctors. And then it was about setting up with Heath his before. Like, this is a man zest for life. And now he's essentially, he's no longer.
So walk me through, I mean, you've touched on a lot of them. So first witness is, and I apologize, I'm forgetting
Susan,
her name, but
the
girlfriend. Why did you call her first?
Because Susan is an unbelievable human being. And, Hannah came up to me, I don't know, like 2.5 months ago, talked to her, and because Hannah was going to be the one that was going to direct her. And she's like, absolutely calling Susan first. She's like, I want the jury to see this case through the eyes of Susan Cottrell. The person who's never left Heath's side. And it's just, also she's a trauma nurse. Just an unbelievable human being. And we felt like that was like the tone setter to get us off with as much momentum as possible.
Was Dr. Shore your second witness?
Called Dr. Shore next. We got them situated, got them down at the stand, really made a big deal about the warning sign. PRT, perception reaction time is a big issue in this case. Sight lines in this case. And then what I really did with Dr. Shore was set the tone for why their action recon was garbage. And we said, you reviewed Mr. Camlin's reports. Did he do a reconstruction? No. Did he do any independent analysis? Absolutely not. And the other thing that I wanted to set with him was that we're dealing with 2 or 3 seconds here. Is that a long time in the accident reconstruction world? And he's like, absolutely. And then one of the examples he gave is, he's like, Saquon Barkley can run, and I know you're a Pittsburgh guy, but Saquon Barkley could run 20 yards in 2 seconds. And he just said, like, it's when it comes to reacting to stuff, it is a really, really, really long time. And that, again, this was not an unexpected occurrence. This was an expected occurrence because he had the advanced warning signs, and he should have been able to, he should have been driving slower, and he had enough time to react, bring his vehicle to a complete stop.
And then from there, were there any other liability witnesses, or did Shore carry the laboring oar for you and you just pivoted into damages?
No, so then we called the defendant, locked him in on a bunch of stuff.
Corporate rep, and then we went into the medical. We had Dr. Michael Lightman, he's the general surgeon from Mount Sinai, to explain, he had exploratory surgery, he had a splenectomy, had a whole bunch of abdominal bleeding. So he walked us through those 2 surgeries that they did, and then played Dr. Mbeo. And any treaters? Did you have any of his treaters in there?
Well, right now he doesn't have any treaters.
Yeah,
which,
gotcha.
And they made a big deal about that, and they said in opening, like, you're not going to hear from any treaters. And in closing, I said, like, yeah, that's right. I'm like, first of all, if we called every treater, we would be here until after Christmas. But what this case is about is, Dr. Mbeo, who you saw, who was just most qualified brain doctor out there, that is who Heath Wilson should be treating with. But he cannot treat with that doctor except if you give him that opportunity.
Yeah.
But so it was just those 2, and then we moved in. We had Varsha, and then the next morning, Romy Toda, Verzilli to give us the economic analysis, and we finished with Heath.
Yeah, Varsha's great.
Oh yeah.
Did you bring? She's out your way, so you probably brought her in live, right?
Yeah, she came live. Romy. The only videos were Lightman and Mbeo, and then we filmed Verzilli just to have, because you never know how the day goes. Always good to have just that one video, and everything. I mean, was very, very clean, short. Mbeo, despite having to walk through severe traumatic brain injury and all of the care that he's going to need, I think it was like 1 hour and 5 minutes with Cross. Lightman was about 30 minutes. Varsha was about 30. Romy was about 15. And Verzilli was 25 minutes.
Yeah. Okay. That's great. So closing, big question. And again, this is from my buddy Andy. Really wants to know. He wants you to walk through what was your from the non-economic component. How did you approach that? I mean, you've obviously got, not even probably all that contested, life care plan numbers, future medical care, anything, specific that you used as like an argument framework to help the jury think about why and how much to enter for non-economics.
So before I went into, right before I finished my economics, the total number with past meds and future meds and all the wages, it was just over like 13 million. And as I was rolling into non-economics, I told him, like, look, that is a big number. But we're going to talk about the non-economics, the human loss in this case, what was taken from Heath. And I'll tell you right now that the human loss in this case is far greater than that economic number that you're seeing in front of you. And then I walked him through, what are the 4 categories? And we had 4 lines, which was fabulous. And I walked him through each one. And then I just took each one. And this was a case where I had a lot of evidence for each bucket, for each line item. And so I walked him through that. But how I framed it was, in these cases where you have so much, it's like, how do you boil it down and be effective and not go through everything all, over and again. And 4:30 in the morning on Friday, the morning of the closing, I kind of shot up out of bed and an idea came to me. So the day that this crash happened, Heath Wilson calls Susan and says, I'm going for a bike ride. Let's have dinner tonight at your house. I'll see you 6 o'clock. Obviously, he doesn't make it to the dinner table. So the opening of my closing, I said, July 16th, Heath Wilson calls Susan Cottrell and says, going for a bike ride. I'll see you for dinner at 6 o'clock. Instead of sitting at that dinner table, he laid in a hospital bed, open from, upper torso to his abdomen, severe bleeding inside of him, every rib cracked, and the worst of all, traumatic brain injury. And so that was kind of how I flowed into it, was that dinner table. And then at the end, what I told them was, as I walked him through all the evidence of everything he's gone to, can't go to the bathroom himself, can't bathe himself, a guy who did all this stuff that, he's laying in a hospital bed at the age of 51. I said, you heard from Heath Wilson. He told you that he never wasted a moment of his life. Members of the jury, you're going to have to give a verdict in this case. And that number, it's going to be big, and that's not easy to do. You're going to look at that number, you're going to have second thoughts, and you're going to think, geez. But make no mistake, that is what justice requires in this case. And it's going to require you to choose hard. It's going to require you to choose a big number. But just like Heath Wilson would never, ever waste a moment of life, Heath Wilson will never waste a cent of that. He will never waste a cent of that, because Heath Wilson, you saw him up on that screen. He will fight, and fight, and he will go through therapy session after therapy session after therapy session, so that one day, whether it be 5 years from now, 10 years from now, or 27.3 years from now, which was the life expectancy, Heath Wilson will sit at that dinner table with Susan Cottrell to have that dinner that he should have had on July 16, 2022. NC.
It's great. Love it. So 2 things. One, well, before I tee this question up, what was the verdict?
So we got every dime we asked for in economics, and then they gave $4 million, $4 million, $4 million, and $4 million for each line. So 16 million non-economics, so 29 and change.
Gotcha. It's awesome. Now, when you referenced the 27 life expectancy, any thought of, as a tug number or an anchor, for maybe a 27 million-ish verdict, or not necessarily?
No, actually, that never came to my mind. I mean,
okay.
because life expectancy was a big thing, and again, they were arguing that he's going to die in 10 years, and so that never came to me. It's just because I knew the judge was going to read that number, and
Yeah,
I just
yeah. And,
that's
and
just how
then,
I feel.
and then my other question, was there any, with the fight, any, playing to your potential political makeup of the people on the jury, with that, or was that just, just the way that you felt and knew was the, really the fighting spirit of your client?
No politics in that. That
Yeah.
was, in his direct, I talked about, are you a fighter? And Susan talked about that. So yeah, no politics played a role in there. But I just wanted them to know that, like, I wanted them to be proud of what they did, and then I wanted them to know that because in telling them to choose hard, and choosing hard, like, this will not go to waste. And when they read the verdict, I mean, as they're reading the verdict, there's people on the jury who were not the foreman who were crying as it's being read.
Yeah.
And, our Susan breaks down. She's sobbing in Hannah's shoulders. And as the jury's filtering out, I'm looking at them, and I'm crying too. They're turning around and they're all looking at her, smiling, like, knowing that, they did right. And for all they know, they put this company out of business, but they did the right thing and they were proud of what they did.
Yeah, right. No, I think that's amazing, and what an amazing experience to be a part of. Have you talked with any of the jurors at all? Just, I mean, any sense of that? And somebody was saying it really is wise overall not to talk to jurors after verdicts anymore, unless they go out of their way, because you might learn something that could become problematic. But
Yeah, I mean, I like if I don't know if I would have asked them anything other than I would have thanked them, for rebuttal. They got up and they did their closing, and I didn't really feel like they made any points that drove anything home. In fact, they said some things that just kind of false. And Hannah was like, I don't even think you need to get up there. She's like, keep it short. So I just got up there and pointed out, like, two things that they said was just absolutely false. And then I just, again, brought it back home to choosing hard and how I did it. We got out early Thursday because the judge had a conference in the afternoon. And so we had lunch, and then Grant and I are having a beer, just talking about different trials. And then he gave me this line that he used. He goes, I think this is going to be perfect for it, is, where you carry the burden and then you pass the burden off.
give it to them. Yeah, yeah.
And it worked out perfect because of the emotion that I showed in this trial. And I said to him, I said, look, when I got the phone call, 2.5 years ago from Susan, I've carried the burden of Heath Wilson, and I'm proud to have proud to do that. And you see that in this case where, when I'm directing Heath and I got emotional, and you see it in my closing that I get emotional, it's because of that burden. And it is a very, very heavy burden. But once I sit down, I'm going to pass that burden to you. And unfortunately, you're going to have to carry it from here on out. And I do not envy you. I do not envy you, because for you to do what is right in this case, you are going to have to make a very hard decision. But we have faith in you. And I forget what else I said, but it was like kind of like that, but just that,
Yeah.
passing the burden and acknowledging again that, like, what you saw from me was real. This was not some, shady plaintiff's lawyer from Philadelphia.
Yeah. No, I think that's great. And I mean, I think clearly, sometimes, yeah, you worry, if you share your emotions, even if they're authentic, if it's still going to come off as, was it crocodile tears or something, and people are going to think that you're just trying to manifest fake emotion to try to manipulate them. But, clearly this case, your authenticity, you were feeling it. You said you were feeling it just talking with him, prepping for him, not even in trial.
Yeah.
And obviously the jury, that resonated with them. So, well, congrats again, man. Amazing case, amazing verdict. I'm glad it worked out for your client so well. And thanks for, sharing a lot of the stuff that that played a part in it to, hopefully maybe some of us can use some of this in our cases, in our trials to get some great results like you've been getting. So once again, man, thanks for coming back. I'm sure this will not be the last time you and I will talk in this capacity. Everybody knows where to find you. Any closing remarks, any last sage advice or words you want to share with my massive audience?
Just get in the courtroom. That's all I got to say is just get there. The more you do it, the easier it becomes, the more comfortable you are, and just be yourself. And I texted my law school professor, and I said, Professor Joyner, I said, in the last 14 months, I've had 3 8-figure verdicts and 2 7-figure verdicts. And I said, I owe you the world for the tools that you gave me, but the most important tool that you gave me was you always allowed me to be me in the courtroom. Like, you didn't try to rein me, like, she reined me in a little bit, but she didn't try to change me, because when I'm up there, I'm probably not what people expect as a polished lawyer. I kind of curse and I do some things. I'm just me, like, I'm authentic. And that's the best thing that she ever did for me, was that you go be you. And that's what I would tell anybody going in the courtroom. Don't try to be Tom Klein. Don't try to be, Mongo. Don't try to be anybody but yourself. And it's the quickest way to success.
Yeah. And like you said, I mean, you want to do this, you actually have to go do it.
Yeah.
There's no other, we can listen to all this stuff. We can read all this stuff.
No fear.
There's no replacement for actually getting in. I haven't tried one since March. I'm going crazy. So hopefully going to try one in January and go from there. But hey, thanks again, man. Awesome stuff. And we'll talk to you soon. Okay, Clancy?
In January, I'll be interviewing you.
Oh, I sure hope so. Maybe February. We'll see. All right.
Thank you,
bud. Until next time.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.